day everyone. So for today's lesson, we will discuss Module 3, the Legislative Department and the role of the Senate and the House of Representatives. So at the end of our lesson, the student should be able to discuss the rules and responsibilities of the Philippine Senate and the House of the Representatives, assess the performance of Philippine Congress, appraise the impact of Congress performance or Philippines development, and articulate a position or advocacy to a Philippine legislator through a formal correspondence. Basic structure. The business of governance in the Philippines constitutes primarily of the three functions, namely the lawmaking functions, the execution of the laws, and the interpretation of laws. The reason is that ours is a government of laws and not of men. So in addition to this, the business of governance in the Philippines constitutes primarily of the three functions, namely the lawmaking functions, the executive of the laws, and the interpretation of laws. So the reason is that ours is a government laws and not of men means the laws govern the country and the public officers only implement the laws, and the acts of implementing the laws are the very acts of governance. So in other words, public officers and their performance duties comply only with what is required of them, which constitute as their functions as the laws to provide. Therefore, to discuss the structure of the Philippine government is to discuss about legislative department with the functions of lawmaking, the executive department with the functions of executing the law together with the LGUs or the local government units as an active partners of governance, and the judicial department with the functions of settling the issues as regards the question of what the law means as applied to certain situations. Basic structure, moreover, it is likewise deals with the Constitutional Commission with their specific and peculiar rule in the Philippine system of governance. And lastly, it deals also about the accountability of public officers. The basis of discussion relative to the function and agencies or officers as above mentioned is the 1987 Philippine Constitution, together with applicable jurisprudence. The lawmaking functions. The lawmaking function is vested with legislator, otherwise known as the Congress. The same is constituted of two houses, namely the Senate and the House of Representatives. Both houses are equal as regards with their rights, duties, and responsibilities. So moreover, each chamber is independent from one another. So however, the law to be duly enacted must be approved with at least the majority votes of the two houses or chambers. Once approved by them, the same is submitted to the office of the President for the latter's approval. If the President voted it by refusing to affix his signature thereon, and Congress wanted to reenact it, the Congress may do so with 2/3 votes of each house. However, when the President failed to act on it, the same shall become a law after 30 days as if he had signed it. Senate. The Senate, which is referred to as the upper house, is composed of 24 senators who are elected at large. 12 senators, however, are elected every 3 years, thereby making it a continuing body with 50% members, thereof whose terms expires every 3 years. This was made possible because during the first senatorial election in 1988, under the new constitution, 24 senators were elected with the first 12 higher votes for 6 years, and the last 12 senators with votes sat for 3 years. Thereafter, all subsequent elected senators were all had 6 years term of office. So as a senatorial candidate, it must be a natural-born citizen. He or she must be a natural-born citizen or a natural-born Filipino citizen resident anywhere in the Philippines for at least 2 years immediately preceding the day of the election and at least 35 years old on the day of the election. So the term of office of the senators shall be 6 years, provided that no one shall be allowed to serve for more than 2 consecutive terms. Renunciation of office for any length of time shall be considered a full term for which he was elected. Qualification of senatorial candidate. Qualification term. A senatorial candidate must be a natural-born citizen, resident anywhere in the Philippines for at least 2 years immediately preceding the day of election, and at least 35 years old on the day of the election. So the term of office of the senators shall be 6 years. So no senator shall be allowed to sit more than 12 consecutive years. Hence, he must be allowed for re-election once, then stop running as a senatorial candidate for at least 3 years, and may run again for the same position. So the purpose of counting the 12 consecutive years, even if the senators had signed or did not finish the 6 terms as senator, the same shall be considered as full 6 years. Next, no senators shall be allowed to sit for more than 12 years or 12 consecutive years. The House of Representatives. The House of Representatives shall be composed of not more than 250 members unless otherwise fixed by law, who shall be elected from every legislative district. Each city with a population of at least 250,000 or each province shall have at least 1 representative. So the members of the House of Representatives shall be elected for a term of 3 years, provided that no one shall be allowed to serve for more than 3 consecutive terms or 9 years. So voluntary renunciation of office for any length of time shall be considered full term for which he was elected. Qualification of House of Representatives. So the members of the House of Representatives shall be a natural-born citizen on the day of the election, is at least 25 years old. He must be a resident in the legislative district where he sought for election for at least 1 year immediately preceding the day of the election. So, at least 20% of the members of the House of Representatives shall be a party list or shall be party list representatives to be elected through their party list organization. Representing the marginalized sectors such as labor, peasant youth, women, and such other sectors as may be provided by law except the religious sector. Party list representative. At least 20% of the members of the House of the Representatives shall be party list representatives to be elected through their party list organization. Representing the marginalized sectors such as labor, peasant youth, women, and such other sectors as may be provided by law except the religious sector. So the party list representatives are elected through the name of the party list, elected nationwide. So every party list which obtained 2% or 2% of all the votes casted for all party lists shall be entitled for one. So set in the House of the Representative but not more than 3 representatives. The representatives of the party list shall be appointed from the list of nominees in order mentioned as subjected to the COMELEC at the time the party list applies for the accreditation with the said of office. Law on party lists. The law on party lists is the Republic Act 7941, otherwise known as Party List System Act, providing for the qualifications of the nominees are as follows. Must be a natural-born Filipino citizen, registered voter, and resident of the Philippines for at least 1 year immediately preceding the election and at least 25 years on the day of election. Next, for the youth representatives, he must not be over 30 years old on the day of election. But if attained 30 years old during his term, he must be allowed to continue in office until the expiration of his term. So, therefore, any elected party list representative who changes his political party or sectoral affiliation during his term of office shall forfeit his seat, provided that if he change his political party or sectoral affiliation within 6 months before an election, he shall not be eligible for nomination under new party or organization. Regular election. Unless otherwise provided by law, the regular election of the senators and the members of the House of Representatives shall be held on the second Monday of May, and their terms of office begins on the noon of June 30 following their election, and shall expire 6 years or 3 years thereafter as regard the senator and congressman respectively. Vacancy. In case of vacancy in the set reserves for party list representatives, the same shall be automatically filled in by next nominee in the order submitted to the COMELEC by the same party list. So any vacancy in the Senate or in the House of Representatives shall be filled in by a special election, as may be provided by law, but the one thus elected shall serve office only for an expired term of his predecessor. Immunity from arrest and speech. Immunity from arrest and speech is a member of Congress cannot be arrested while Congress is in session if accused of a crime, with a penalty of not more than 6 years imprisonment. Nor shall any member be held liable in any other place for any speech or debate in the Congress or any committee thereof. So in People versus Halosos, in February 3, 2000, the Supreme Court explained why a member of the Congress convicted by the trial court of non-bailable offenses should not be allowed to perform his duties. So when we say non-bailable, so hindi pwedeng pagpiyansahin. So thus said the High Court with the following: membership in the Congress not exempt and accused from statutes and rules which apply to validity incarcerated person. So one rationale behind confinement, whether pending appeal or after final conviction, is public self-defense. It would amount to the creation of privileged class without justification in reason. And lastly, accused appellant is provided at the House of Representatives with a full complement of staffs, as well as an office at the Administration Building, New Bilibid Prison, where he attends to his constituents. Violation of House rules. Members of Congress may not be held liable for whatever they said during the performance of duties. Nevertheless, they may be held liable for violation of the House rules. Officers. The Senate shall elect its President and the House of Representatives its Speaker by the majority votes of all the representative members. Each House shall choose such other officers as it may deem necessary. With a quorum, a majority of each House shall constitute a quorum to do business, but a smaller number may adjourn from day to day and may compel the attendance of absent member under pain of penalty as they may be prescribed. So, a majority of each House shall constitute a quorum to do business, but a smaller number may adjourn from day to day and may compel the attendance of absent member under pain of penalty as they prescribe. The Congress shall convince once every year on the fourth Monday of July for its regular session, until 30 days after the opening of the next regular session, unless the law fix another date. The basis for the termination of quorum is the number of senators who are in the country and within the coercive power of the Senate. Moreover, the Supreme Court said that the issue of quorum cannot be raised repeatedly when a quorum is obviously present for the purpose of delaying the business of the House. Rules of Proceedings. Each House may determine the rules of its proceedings, punish its members for disorderly behavior, and with the concurrence of two-thirds votes of all its members, suspend or expel a member. A penalty of suspension when imposed shall not exceed 60 days. Each House may determine the rules of its proceedings. Suspension. The suspension within the context is a penalty for the misbehavior of any member of Congress, which each House can impose against the respective members in consonance with the rules of each House. This is not the suspension contemplated under Republic Act 3019, otherwise known as the Anti-Graft and Corruption Practices Law. So when they said the Supreme Court in this regards, the suspension contemplated in the Constitution is different from the suspension prescribed in the Anti-Graft and Corruption Practices Act. The latter is not a penalty but a preliminary preventive measure and not impose the petitioner for misbehavior as a member of Congress. So the Supreme Court further said that the order of suspension provided in Republic Act 3019 is distinct from the power of Congress to discipline its own ranks. Neither does the order of suspension upon the power of Congress for the doctrine of separation of powers by itself is not deemed to have effectively excluded the members of Congress from the said law. Passage of a bill into law. So every bill passed by the Congress shall be presented to the President for approval. It should be approved by either House upon 3 readings on separate days, and it shall contain one subject which shall be expressed in the title thereof. So only one subject to be expressed in the title. It is said that the title is not required to be an index of the bill. It is sufficient compliance if the title express the general subject and all the provisions of the statute of germane to the subject. Journal. Each House shall keep a journal of its proceedings, which shall be published from the time to except those which to its judgment shall concern national security, in which case the same shall be kept secret. So the votes of any question shall be recorded in the journal upon request of at least 1/5 of the members present. So each House shall also keep a record of its proceedings. Enroll Bill. An Enroll Bill is one duly introduced and finally passed by both houses, authenticated by their respective officers, and approved by the President. The Enroll Bill is conclusive upon the courts as regards the tenure of the measure passed by the Congress and approved by the President. The court is bound by the doctrine of separation of powers by the contents of a duly authenticated measure of the legislator. When there is a conflict between the Enrolled Bill and the journal, the former prevails except on matter, which under the Constitution must be entered in the journal. Veto of the President. So when the President vetoed the bill, shall return the same to where it is or it was originated. Congress may override the veto of the President by 2/3 votes of all members thereof. So the veto of the President and the reconsideration of the same by Congress, which affirmative and negative votes shall be entered into the journal. RAT bills. All appropriation, revenue tariff bills, as well as those which increase public debt, and bills of local application, including private bills, shall originate exclusively in the House of Representatives, but the Senate may propose or concur with amendments. In Tolentino versus Secretary of Finance, it was said that it is not the law but the bill which is required to originate exclusively in the House of Representatives, because the bill may undergo such substantial changes in the Senate that the result may be a rewriting of the whole. As a result of the Senate action, a distinct bill may be produced. So to insist that the revenue statute, not just the bill, must be substantially the same as the House bill would be to deny the Senate's power not only to concur with amendment but also to propose amendments. It would violate the co-equality of the legislative power of the Senate. So therefore, the Constitution does not prohibit the filing in the Senate of a substitute bill in anticipation of its receipt of the bill from the House, so long as an action by the Senate as a body is withheld pending receipt of the House bill. Non-legislative functions. Congress has also functions assigned by the Constitution, which strictly speaking has nothing to do with the lawmaking. These are the non-legislative functions as follows: Electoral Tribunal, investigative functions, question hours, declaration of Senate of War, canvasser, confirmation of VP, determination of residence disability, commission on appointment, and martial law power of Congress. First, we have Electoral Tribunal. The Senate and the House of Representatives shall each have an electoral tribunal, which shall be the sole judge of all contests relating to the election returns and qualification of their respective members. So each tribunal shall be composed of 9 members, 3 of whom shall be justices of the Supreme Court, to be designated by the Chief Justice, and the remaining 6 shall be members of the Senate or the House of Representatives. So as the case may be, who shall be chosen on the basis of proportional representation from the political parties or organization registered under the party list system. So the senior justice in the Electoral Tribunal shall be its chairman. So the Electoral Tribunal is independent of the Houses of Congress. So, and its decision may be reviewed by the Supreme Court only upon showing of grave abuse of discretion in a petition for a certified file under Rule 65 of Rules of the Court. But the House of Representatives Electoral Tribunal may assume jurisdiction only after the winning candidate, who is a party to the election controversy, shall have been duly proclaimed, has taken his oath of office, and has assumed the function of his office, because only then that he is said to be a member of the House. The court has already settled the question of where the jurisdiction of the COMELEC ends and where that electoral tribunal begins. The proclamation of a congressional candidate following the election returns and qualification of the proclaimed representative in favor of the House of the Representative of the Electoral Tribunal. Punishment for contempt. Any witness who refuses to attend a legislative investigation may be punished for contempt, which includes indefinite imprisonment, subject, however, to due process. the Supreme Court declared that the contempt power of Congress includes the grant of the same to congressional committees. So the importance of the power of contempt in a legislative inquiry grants the power not only the Senate and the House of Representatives, but also their respective committees. A reasonable conclusion in that the conferment of the committees of Congress must carry with all its powers necessary and proper for its effective discharge. Winning candidates. The person having the highest number of votes for president and vice president shall be proclaimed elected. But in case two or more persons shall unequal in highest numbers of votes, one of them shall be chosen by the majority votes of all members of Congress voting separately. And so far as it grants sweeping authority to the COMELEC to proclaim all winning candidates is unconstitutional, as it is repugnant to that the Congress the authority to proclaim the winning candidate and vice president. Legislative veto. A legislative or congressional veto is a means whereby the legislator can block or modify administrative action taken under a statute. It is a form of legislative control in the implementation of particular executive action. So the form may either be negative or positive. It is negative when the executive action is made subject to the disapproval by Congress, and positive when the executive action court ruled on the issue without directly touching legislative veto. So it says that in the special provision number 2, so on the use of funds in the appropriation for the modernization of Armed Forces of the Philippines, General Appropriation Act of 1994, which requires prior approval of the Congress for the release of the corresponding modernization funds, is implementing a law or requiring approval for executive acts, must be incorporated in a separate and substantive bill. Okay, so now let's proceed to Module 4, Decentralization and Local Governance. So at the end of our lesson, the student should be able to identify the different levels of Philippine local government, explain the rules and functions of the local government unit, examine how decentralization affects governance, and conduct an interview with barangay official on community programs, and evaluate the performance of the local government unit. Local governance. The system of governance in the Philippines is largely shared between the national and local governments. The latter has the direct contact with the people and more accessible to them. Besides, local government units in general are more acquainted with the problems of their respective constituents. Likewise, they are supposed to provide immediate response to whatever emergency situations where such quick response is urgently needed in one place or locality. Political subdivision. The territorial and political subdivision of the Republic of the Philippines are the provinces, cities, municipalities, and the barangays. There shall be autonomous regions of Muslim Mindanao and Cordilleras as hereinafter provided. Local autonomy. Autonomy is either decentralization or administration or decentralization of power. The second is an abdication by the national government of political in favor of the local government. So the first consists merely in the delegation of administrative powers to broaden the base of the government or governmental power. Against the first, there can be no valid constitutional challenge. Hence, the context of local autonomy under the Constitution is delegation of the administrative power from the national government to the local government units, whereby the latter is under the supervisory control of the former. Congressional control. Thus, even as we recognize that the constitutional guarantee on autonomy to local government units, the exercise of local autonomy remains subject to the power of control by Congress and the power of general supervision by the President. So in the Philippines, devolution defines as the act by which the national government bestows power and authority upon local government units to perform specific functions and responsibilities. Moreover, devolution usually transfers responsibilities for services to municipalities that elect their own mayors and councils, raise their own revenues, and have independent authority to make investment decisions. Taxing power. Each local government unit shall have the power to create its own sources of revenues and to levy taxes, fees, and charges subject to such guidelines and limitation as the Congress may provide, consistent with the basic policy of local autonomy. Such taxes, fees, and charges shall accrue exclusively to the local governments. So in the 1987 Philippine Constitution sets limitation on the exercise of the power to tax. In addition to national taxes, the Constitution provides for local government taxation, but no such taxes, fees, and charges shall be imposed without a public hearing, having been held prior to the enactment of the ordinance.